Basically, for you to enforce a contract between parties, both locally or internationally, there are some basic things you must watch out for you to actually say there is agreement or there is a contract between these two parties. First, there must be an offer made by the promisor to the promisee. Secondly, there must be a valid acceptance made by the promisee to the promisor. And then thirdly, there must be what is given in return or a detriment suffered in order to allow that contract to settle. That is what we refer to as consideration. Fourthly, there must be an intention to create a contract between the parties, what we regard in law as consensus addendum. And then lastly, the both parties to such a contract must be in equal standing. I mean, they must have the capacity to contract, because a contract entered into with the minor is not usually enforceable against the minor. So this will lead us to what we are going to discuss in this video, which is consideration. Have you heard of the word consideration? Or do you think the word consideration in its ordinary meaning is what it applies to contract? That is what we are going to check on this video. Let us see what considerations means. I will still provide you with case authority that properly or judicially described and define consideration. But before I go there, I want to clarify the word consideration to you. If you hear the word consideration, it simply means what the party has exchanged in order to bring into existence a contract. I will give you an instance. Consideration as a glue, or rather a super glue, something that binds a contract. Remember, we have discussed offer, we have discussed acceptance, we have discussed counter offer, we have discussed how to terminate an offer. Today we are dealing with consideration. If you want to see all those videos, kindly go to our playlist. We are going to see them, the one that has to do with playlist on law of contract. So see consideration as a glue that binds a contract. If there is an offer, there is an acceptance. What unites it together to metamorphose or form it into a contract legally binding is what we call consideration. That is something you have given or something, the exchange made between the parties to make it a binding. And when you are talking about consideration, it simply means that for you to enforce a contract, there must be a presence of consideration. Remember, we say that contract, all these things are elements of contract. Offer, acceptance, considerations, they are all elements of contract. An absence of one can vitiate the entire contract. Absence of a valid acceptance can vitiate as an entire contract. Absence of a valid offer can also vitiate an entire contract. So also, absence of a valid consideration can also vitiate the entire contract. That is what we are saying. So when there is no consideration, when no party has given something in return, it means there is no contract. For instance, if I promise to buy you a car, just willingly meet you and say, "Hi, my guy, you are doing well. You are a sound person. Your knowledge is commendable. I will buy a car for you next tomorrow, or I will buy a car for you before the Christmas comes." In this case now, I made you a promise, right? There has been an offer, right? You also, okay, you accepted by saying, "Oh, thank you, sir. Thank you, King's Advocate. I really appreciate your kind gesture. Who am I? Thank you." You have accepted. But in this case now, if I fail to honor my word, there is no law that will hold me responsible for not fulfilling my promise, because there is absence of consideration. Do you get the point? I made you a promise, but I didn't fulfill that promise. That promise cannot be enforced simply because you did not furnish any consideration. You did not put anything in return to the exchange of my promise. But had it been I told you, "You are a young man, you are a brilliant student, a lawyer in equity. Please, can you help me and interpret this thing for me? Can you help me and read this thing for me? And after you are done, I'm going to compensate you with at least some money so you can use it and take care of yourself." You said, "Okay." In this case now, if you perform that act of reading or doing whatever I have asked you to do, in this case now, you have exchanged something in return. And I want you to get this point. When you are talking about consideration, it doesn't necessarily mean that it must be that big. Any little things. When we shall go to the authority that define this consideration, that is when you are going to properly understand what I'm saying. Regardless of how tiny, regardless of how small it is, once you have done that in exchange of a particular contract, it becomes a consideration. Because the court has held in the case of Thomas and Thomas that consideration doesn't need to be that big. I can approach you and simply tell you, "Please read this book to me. I'm going to offer you 1 million naira. Okay, you accept and you read that book, or you do whatever I have asked you to do. Regardless of whether that 1 million amount of money I promise you, what you did to me is immaterial before the courts. Or regardless of what you have done to me in favor is too big, that 1 million naira is not enough, that is immaterial. What the court need in this case is whether there was a valid something that was given in return. It is immaterial how big, how small it is. What the court need is, have you fulfilled that? Have you done something? Have you suffered a harm? As we proceed to the authority that define consideration, you are going to see that consideration doesn't just end with money. It could be a detriment. It could be forbearance. It could be something that you would have ordinarily enjoyed, but you allow it to be because of a particular thing. That, in the eyes of the law, is what we call consideration. See consideration today as something of value which has been exchanged between parties in order to bring contract into existence. But remember, he who has sat must prove. It doesn't just end with that. Let us see the case authority that give consideration credence, or a judicial paracetamol to what we mean by consideration. And a locus classicus case, that is the real authority. Whenever you hear me say locus classicus, it simply means the real case that illustrates a particular principle. And of course, common law is case and case is common law. A real case or a locus classicus that illustrates and defines consideration is the case of Curie and Misa. In that case, the court enunciated the principle that defines considerations. According to the court in that case decided in 1875, consideration is defined as some rights, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by others. So, by going by this definition, it simply underlines that consideration doesn't always have to be positive benefit. It can also be a burden of detriment assumed by one party. I want you to get this gist very well and concise. Consideration, like I told you ab initio, doesn't necessarily need to be money. It can be monetary, yes, I agree. But there are some times it could be forbearance. I will give you an instance. If I slap you, if I give you a dirty slap, that brown one, you will feel bad. And you can maintain an action under law of tort for battery and assault. But in this case now, if I pleaded with you, say, please don't go to court, I am sorry for what I did. For the fact that I've slapped you, I'm going to compensate you. Please, I have really embarrassed you before this general public. What do you want? Or I will do this for you, I will do that for you. If I fail to honor my word, you can maintain an action. How you can maintain an action now? You can sue me under the law of contract, not under the law of tort again. You can still proceed under the law of tort to sue me for battery and assault. But if you don't have that energy, you can still maintain the law of contract to enforce, to command me to enforce my promise. Because in this case, I have slapped you. What you have suffered, that detriment of slap or forbearance, you enduring that slap instead of maintaining an action in the first place, can be regarded as a consideration. So consideration can be detriment. That is what you have suffered. It can be forbearance, that is your endurance of a particular thing. Somebody has trespassed under your land, somebody have harmed you, but you wish not to maintain an action. That has become a forbearance under a particular promise made by a promisor. I hope you get my point. That is what we mean by consideration. The court in the case of Mose and Curie is simply telling you that consideration need not to be monetary. It need not to be anything. It can be forbearance, that is your patience. It can be any other thing apart from monetary. So when your lecturer approach you with this question in the examination hall, they could paint the scenario in such a way that you should be in a better position to actually say there has been a consideration. I will give you instance, like I normally do in all my video that has to do with contract. I normally use breach of promise of marriage always as an instance because it's a clear example. We all are in a relationship. If you are not, I am in a relationship. So if there is a relationship that exists between you and person, maybe you promise to marry somebody and that person has accepted. Okay, you promise, you Stanley watching this video, you promise to marry Nkechi, and Nkechi has wholeheartedly accepted everything and said, okay, I'm going to wait for you. Just make your money and come back. Nkechi has been rejecting so many suitors that has been coming her way. She has been consistently rejecting all of them. If you come back later and say that you're not going to marry Nkechi, when you have made a valid promise and Nkechi was relying on that promise or acting on that promise of rejecting so many suitors with the hope that you, Stanley, watching this video, is going to marry her, she can maintain an action against you, and the court will not necessarily enforce you to marry Nkechi, but the court will award the damages in favor of Nkechi because you have breached a promise. Nkechi in this case has suffered harm, and the harm, what he has suffered in this, that detriment of rejecting so many suitors becomes a consideration. Or come to think of it the other way around, you, Mr. Taiwo, that is watching this video, you have made a promise to Fadilat that you are going to marry Fadilat, and Fadilat wholeheartedly accepted. Fadilat said, okay, please, you can send me to school so that I will finish my LLB and I will come back and marry you. You sponsored Fadilat, you did everything for Fadilat as a Taiwo, and now Fadilat has come back and said she's not going to marry you. She's tired of you. You are looking so stupid and nothing. I'm not going to marry you. In this case now, because of that, your sponsorship, because of everything I've done for Fadilat, with the hope that you are going to marry Fadilat, and wholeheartedly, remember, consideration is not just enough to make a contract valid. There must have been an intention to contract in the first place. Fadilat must have been in better capacity to appreciate and understand that actually what we are doing for him was for the purpose of marriage later on. If you are just being Father Christmas, you know, some guys can be so stupid that they will be spending on the woman with the hope that when that woman, like all those things, going to enter the woman's head and make the woman fall in love at the right time. You keep wasting your money with that view, that notion that when Fadilat, you know, understand my goodness, she's going to say, I will marry you. If you are doing it on your own on Father Christmas basis, the court will not enforce it. That's why we say all this element of contract flow from offer to acceptance, from acceptance to consideration, from consideration to intention to create a legal obligation. That is what we regard as consensus addendum. Consensus addendum. From there again, you move to capacity to contract. We are not dealing with those ones. We have made offer, we have made acceptance, we have made counter offer, we are now in consideration. Next week, we're also going to consider intention to create a legal obligation, and then we proceed from all the elements. So far, we have covered about 4 elements so far. So it is very important you understand it. Consideration is just a one side of it, and consideration is like a super glue. See it that way. Consideration is what binds a contract, is what gums a contract together. Absence of it, you cannot enforce it. Another locus classicus authority to watch out for is the case of Dunlop pneumatic tire vs. Selfridge. That very case of Dunlop pneumatic tire vs. Selfridge, the court also made an attempt to describe what consideration is. According to the court in that case, the House of Lords emphasized that only a party who has provided consideration can enforce a contract. So this case established the principle of privity of contract, meaning that a contract cannot confer rights or impose obligation on anyone except the parties is involved in that contract, so to say. The case of Dunlop pneumatic tire and Selfridge is also another serious case to watch out for in your second semester, where you will be dealing with privity of contract. That case anchored the principle that for you to actually enforce a contract, you must be a party to that contract. And not only that you must be a party, you must have furnished something in return. The only exception to this is the trust principle of trust, which is also an entire different. I don't want to get into there because it's a entire doctrine of its own. But the only exception to that is that, so if there is a contract, for you to actually enforce it, you must have furnished a consideration. And any other thing is known as gratuitous promise. So in the absence of consideration, any promise that is made in the absence of consideration, what we call it is a gratuitous promise. And a gratuitous promise is simply a promise that is not enforceable under the law. And we're also going to consider types of consideration, because actually consideration is a broad topic, and that is where most of the whole question in contract law as far as first semester work is concerned will basically proceed from. So today basically our emphasis is on definition of consideration. I earlier pointed out the case of Thomas and Thomas as a locus classicus to when talking about consideration. Now I'll basically provide you with a brief fact of that case. That case simply has to do with the John Thomas. Before he passed away, he promised his wife Thomas, Mrs. Thomas, that is going to occupy the particular building where he was living. Then when he died, the particular promise was not written under a will. It was an oral contract. And you know, for you to enforce an oral contract, there must be either consideration attached to it. And I explained earlier, based on absence of consideration will render a contract or a promise not enforceable, as I explained earlier. So in this case, now when he died, there was nothing like a written document, but the executor of the Thomas will, however, allowed Mrs. Thomas to live on that particular estate, but they gave the woman condition now that she's going to promise to keep the house and also pay a £1 to that effect in order to bring that contract into existence. That is for them to allow that woman to live on that building. Then the woman said okay and accepted the whole proposal and also made a payment of £1. Then later on, the executor of the will of Thomas, there were many people that were in charge of that. There were many people that were in charge of that. So some part of the people involved then say that they will not agree to this. How can £1 be enough for this woman to occupy this entire promise? When I mean executor of a person will, I mean those who are to carry out all his will when he have died. Those who are in charge to Mr. Thomas' estate as he proceeds to the world beyond. So those people then, one of them say that they are not going to allow this woman to stay on this building because £1 is not enough. Come to think of it. When they got to the court, the question before the court was, is £1 enough consideration to allow this man to occupy this whole estate, this whole building? The court by Peterson J held that consideration need not to be sufficient, though it must be adequate. That is to say, consideration needs not to meet or be equal to particular favor you have received. The only thing that is needed is that you have furnished consideration. In the eyes of the law, even if I promise to give you a single pen like this, and you promise to offer me 1 million naira, and we accept the proposal, the court will not care whether this thing was enough for you to actually get a 1 million. So if there is a promise of 1 million in the exchange of this pen, and I fulfill my own condition, and you fail to fulfill your own, the court will not be called to question whether this pen was enough to give you 1 million. You get? What the court will definitely check whether there was a consideration. No matter how little, no matter how big, the court will basically enforce it. And the next week, we are going to consider the valid conditions that must be in place for you to actually say this consideration is a valid one. From there, we also move to types of consideration. I believe this video explained to you as a beginner what consideration means. Remember the case I pointed out, go through it and read it, because that is where the whole cases and the whole examination question is going to come from. And cases in common law remain the same. This case I pointed out here applies to all countries you are watching this video, provided it's a common law jurisdiction. Please subscribe to this video, and if you wish to watch all my videos that has to do with contract acceptance, click the link above. The 2 videos above there is going to help you. I will see you next week.